Can a woman legally get pills through the mail to end a pregnancy without leaving her home? Wait! Listen to this video through to the end before you make that click. Good morning, ladies and gentlemen. This is another declaration of truth from your host, Terry A. Hurlbut. Yes, I've read the recent Justice Department opinion saying that the department will not prosecute people for shipping that kind of medicine by mail because no one can show intent on the part of the recipient for using it for an unlawful purpose. A well-respected legal commentator who was once part of the Office of Legal Counsel says, not so fast. Before I get into details, I do want to shout out to the prime sponsor of this channel, which is Conservative News and Views. Link in the description. And be sure to check on the awesome CNAV Store. Scroll down near the bottom for that link. Lots of great merchandise there, especially this t-shirt that I have chosen for today, which shows a diagram of an unborn child in the womb and has this wraparound caption, not your body, not your choice. And one more thing, if you like what you're about to hear, you can like this video. You can also click the bell icon to get a notice every time I come out with a new one. In fact, do you see the new icon, the heart shape with the US dollar sign in it? That's the super thanks icon. If you really want to keep these videos coming, click that and leave me a tip. Any currency will do, as long as it's legal tender. Now then, as I have often said before, I am not a lawyer. I went to medical school, not law school. So I defer to lawyers whenever they weigh in on topics like this. The particular lawyer to whom I am deferring today is Ed Whelan. He serves as the Antonin Scalia Chairman for Constitutional Studies at the Ethics and Public Policy Center. And he writes a column for National Review titled Bench Memos. Well, he weighed in on this issue less than 2 weeks ago. He produced a 3-part series, which I'm going to summarize. But last summer, he wrote an opinion on this matter shortly after the Supreme Court issued its landmark Roe reversal. You know the case. Dobbs versus Jackson Women's Health Organization, docket number 19-1392, which now has at least part of a permanent law book style citation. 597 U.S. blank 2022. The blank will give place to a page number once the finished law book is ready to order. Now, on December 23rd, 2022, Assistant Attorney General Christopher Schrader, writing for the Office of Legal Counsel, or OLC, delivered an opinion on whether it would be lawful or unlawful to send a certain set of pills, which I will call A pills, through the mail. I have left a link to that opinion in the description. You will hear him refer to 2 different drugs, which I will name right now, only once, to get this out of the way. Here is where my medical degree comes in. The first is mifepristone, a drug we used to call RU-486, that the French drug maker Roussel Uclaf developed specifically to, well, end life in the womb. The other is misoprostol, a member of a class of drugs that in my former profession they call prostaglandin analogs, that essentially trigger labor. Now that's as much as I'm going to say about these drugs, which from now on I'm going to call M1 and M2. So, here is what Mr. Schrader said. Quote, "We conclude that Section 1461 does not prohibit the mailing or the delivery or receipt by mail of M1 or M2 where the sender lacks the intent that the recipient of the drugs will use them unlawful. This conclusion is based upon a long-standing judicial construction of the Comstock Act, which Congress ratified and the United States Postal Service itself accepted. Federal law does not prohibit the use of M1 and M2. Indeed, the U.S. Food and Drug Administration, the FDA, has determined the use of M1 in a regimen with M2 to be safe and effective for the medical termination of early pregnancy. Moreover, there are manifold ways in which recipients in every state may use these drugs, including to produce an A-word, without violating state law. Therefore, the mere mailing of such drugs to a particular jurisdiction is an insufficient basis for concluding that the sender intends them to be used unlawfully. In 1872, Mr. Anthony Comstock, drawing inspiration from the moralists of Victorian England, proposed certain laws to stop the sending of certain materials to the mails. Today, the Comstock Act, as amended, Title 18 U.S. Code, Section 1461, forbids mailing anything designed, adapted, or intended for ending a pregnancy, or for any indecent or immoral use. Now, by immoral use, that law means contraception. That includes every drug that one advertises or describes in a way to use it to end a pregnancy. Furthermore, the Comstock Act forbids any junk mail or targeted mail either telling someone where to get A-pills or what can serve for A-pills, or inducing or inciting someone to use A-pills. The penalties for violations start at less than 5 years for the first offense and less than 10 years for each subsequent offense. Furthermore, Section 1462 extends the same prohibitions to private express companies. That is your FedEx, UPS, Airborne, DHL, those guys. But this opinion plays fast and loose with that law. Assistant A.G. Schrader reminds everyone that federal laws don't forbid A-pills. That's fine. Then he says that M1 and M2 have uses other than as A-pills. Specifically, an OB-GYN might use M1 and M2 to treat a miscarriage. Also, a gastroenterologist might use M2 to prevent or treat stomach ulcers. So, merely sending the pills in the mail is not enough to prosecute someone under the Comstock Act. So says Assistant A.G. Schrader. Now, I'm going to talk about Mr. Whalen's opinion, but first, I want to shout out to a sponsor who can really help you through the economic storms to come. That sponsor is oursilverlines.com. Do you feel like you're working harder for your money just to get by? You are not alone. The fluctuating economy, employment issues, and unexpected changes in life have left many families struggling over the past few years. Collecting gold and silver can help shield you against many of these challenges. But if you're like me many years ago, you don't know where or how to start. Our Silver Lines helps by connecting you with thousands of members who are learning the secrets to creating and protecting true wealth by collecting precious metals. Whether you just want to collect rare and unique coins or take advantage of the business opportunities this company provides, either way, they can help you learn to live an exceptional life. Visit oursilverlines.com to learn how you can build a legacy for your future. Now, Mr. Whalen said 3 days after Dobbs came down that, of course, Roe constrained the enforcement of the Comstock Act. Now that Roe is gone, the prohibitions against sending A-pills become fully enforceable. The prohibitions against sending the junk or targeted mail telling people to use them and how, where to get them, and so on, might fall before the First Amendment. As to contraceptives, those prohibitions might fall before Griswold versus Connecticut. That is, until Justice Thomas has a chance to overrule it. Go look at his concurrence in Dobbs, in which he objects to substantive due process as a valid consideration of constitutionality. Whalen also said that even if the Justice Department declines to prosecute, the next administration could go back and prosecute any violation that happened 5 years before any change of administration. 5 years being the statute of limitations. the Justice Department is obviously determined not to enforce the Comstock Act. More than that, now they've given an opinion that there's nothing illegal about sending aid pills through the mail. Evidently, as long as the one ordering them declares no intent, the Justice Department couldn't prosecute. In other words, don't ask, don't tell, or ask me no questions and I'll tell you no lies. To arrive at that conclusion, says Whalen, Schrader misread the case of Bours versus the United States in the Seventh Circuit in 1915. I have a link to that case in the description. This case involved the law as it stood very early in the history of the Comstock Act. Bours applies to that version of the Comstock Act that then in force. The opinion of the Seventh Circuit in Bours refers to a certain word for ending a pregnancy, and let's just say the A word. The opinion says in relevant part, quote, in applying the national statute to an alleged offensive use of the males at a named place, it is immaterial what the local statutory definition of a word is, what acts of a word are included or what excluded. So the a word in the national statute must be taken in its general medical sense. Its inclusion in the statute governing the use of the males indicates a national policy of discountenancing that procedure as inimical to the national life. Though the letter of the statute would cover all such acts, the rule of giving a reasonable construction in view of the disclosed national purpose would exclude those acts that are in the interests of the national life. Therefore, a physician may lawfully use the males to say that if an examination shows the necessity of an operation to save life, he will operate, if such in truth be his real position. So that precedent specifically protects a doctor who ends a pregnancy to save the life of a mother. Other than that, this case still leaves intact the prohibition against mailing anything to end a pregnancy. In part 2 of his series, Whalen covered Bours again, and 3 more cases Schrader cited to hold that a prosecutor must show intent to end a pregnancy and to prosecute someone for shipping these pills through the mail. Wrong, says Whalen. Some of those opinions merely speculated in obiter dicta, that's Latin for by the way sayings, something to that effect. Any actual holdings in those cases say that a positive showing of lawful intent would be adequate defense against a charge under the Comstock Act. Whalen says more. Apart from any other consideration, these are not Supreme Court cases at all. They are circuit appeals cases. Furthermore, the cases on which Schrader relies represent a minority of circuits. In his part 3, Whalen sums up, you cannot reasonably infer that Section 1461 offenses are not prosecutable unless the prosecution can show intent. Furthermore, of all the cases Schrader cited, only one, the Bours case, even mentions the word for ending a pregnancy. Katie Yoder, writing in Life News, gives more history. The FDA allowed people to ship aid pills through the mails in December of 2021. They did this in the face of warnings against prescribing such powerful drugs sight unseen. Shortly before that decision came down, the Charlotte Lozier Institute produced evidence that the use of these drugs to end pregnancies were bringing women to the emergency room more than 6 times as often as they ever came before. So this A-pills tangle results from a common misconception of American law. Contrary to popular belief, American law does not have a Koran-style abrogation principle. That is to say, one law does not automatically repeal all contradictory laws that came before it. Instead, the drafters of a new law must explicitly say such a title of the United States Code in such a section is amended to read, or is stricken from the record. They then must give the changes in the law. Congress, as Whalen pointed out, did try once before to change the Comstock Act. In 1978, 5 years after Roe, they did not. In fact, Congress' last amendment to Title 18 U.S. Code sections 1461 and 1462 in 1994. Congress did so before the famous midterms that broke decades of Democratic control of the House of Representatives. And that is the form that now holds. So the only way to make those strippers of A pills absolutely safe is to repeal those sections of Title 18 in their entireties. Well, Paul Begala, who once served as counselor to President Bill Clinton, coined a certain infamous aphorism. You know the words: stroke of the pen, law of the land, kinda cool. Christopher Schrader seems to think he has a similar power, but the law doesn't work that way. Mr. Whalen did not mention one other thing that pro-life activists in this country can do in this regard. File a citizen's complaint. Any citizen may file a complaint with the Justice Department to force a review of any given matter, especially if it's criminal or might be criminal. This is how Alfred Freddy Kassab famously forced the eventually successful prosecution of Captain Jeffrey R. McDonald, U.S. Army Medical Corps, for the murders of his wife and children in his quarters at Fort Bragg, North Carolina in February 1970. In September 17, 2021, Captain McDonald withdrew his last bid for release from prison. If you've been around as long as I have, you might have heard of a book titled Fatal Vision by Joel McGinnis, which covers that case. Of course, the citizen's complaint process offers no guarantees. Not every investigation moves from citizen's complaint to prosecution, but Jesus' parable of the widow who pestered a lazy judge to get justice should serve as an instructive reminder. Luke chapter 18, verses 1 through 8. Links in the description to the article, to the opinion by Mr. Schrader, to Dobbs versus Jackson Women's, to Title 18 U.S. Code sections 1461 and 1462, to Bours versus United States, to my Declarations of Truth Twitter account, and to Conservative News and Views. I've also left links to the awesome CNAV Store and to rsilverlines.com, as I also mentioned. You know already about how to like a video, turn on notifications, and leave a tip. On the end screen, I'm going to leave a subscribe link to my channel and links to earlier videos that I've done on the subject of Roe versus Wade going down and related matters. This is Terry A. Hurlbut delivering another declaration of truth and reminding you to let the truth set you free.